Welcome to the Jurist Law Podcast.
Welcome to the Jurist Law Podcast with Kimbro Stephens and Shane Cox. Kimbro serves as managing attorney and Shane as chief legal counsel at Jurist Law Group. With rich backgrounds in healthcare and elder law, they help families navigate the complexities of long-term care, asset protection, and estate planning. I'm Lisa Mosby, your host, and today we're talking about what happens under Arkansas law if someone passes away without leaving a will, and how that situation can affect families, property, and the probate process. Welcome, Kimbro. Welcome, Shane.
Thank you for having us.
Thank you, Lisa.
Yeah, many families assume everything will automatically go to a spouse or to their children if someone passes away without a will. Under Arkansas law, what actually happens when a person dies without one?
I think your question is rightfully skeptical of that misunderstanding, which it is. So Arkansas is a title state, which basically says that what you own in your name is yours. So typically when people buy a residence, for example, and I say residence for a reason, and their husband and wife, it will go to the spouse, right? But spouses can own property and bank accounts and stuff in their name only, and that will not automatically go to the spouse. So that, if that's the case, those such assets and a few others would be subject to probate because we need court intervention, and that's what probate is, to essentially say this is where it goes to. And honestly, just spoiler alert, sometimes Arkansas law kind of puts the surviving spouse at headbutting against the children as to certain assets. So it can be problematic, and we certainly want to try to avoid it.
Yeah, and just to piggyback onto that, spouse is not necessarily next of kin in Arkansas if the deceased spouse has children, and it could be children of both or otherwise, and that has to do with real estate. If you have a married couple and they don't own the property as husband and wife jointly, of course you don't need a will because it goes to the surviving spouse. But if your spouse is the one who owns the title, for instance, they bought the house in their name and then got married and never added their spouse to it, then without a will, that spouse is not going to inherit that property. They may, in Arkansas, have a right of dower, which means they can occupy the premises, but it's going to go to the children. And then it's going to cause the children and the spouse to butt heads when it comes time to selling the property, what's going to happen with it. So a will is an opportunity to direct what's going to happen to that home if your spouse's name is not on it. And a lot of people don't understand that. They just assume that the wife is going to get it, or the husband, in that matter, if it's owned by the wife. That is not the case in Arkansas. The other side of that equation is, what about personal property without a will? Well, again, if there's children, the children get 2/3 of all personal property in Arkansas, and the surviving spouse gets 1/3. That may, create some unintended consequences again. And one way that we tell that to families is if you don't have a will, the state has one for you. And you might not want what the state has. So it's a very good idea to have a will to make sure that your wishes are followed and not what the state says.
That's well said.
Yeah, and that's basically what happens.
Yeah. The term intestate means or often comes up in these situations. Can you explain what dying intestate means and how Arkansas law determines who inherits?
Yes, absolutely. So intestacy or intestate just means that the person that's passed away did not have a will. Okay. And so inherently in that is that we're probably going to have to go to probate court. So, and as Kimbro alluded to, if you don't have a will, meaning you died intestate, then Arkansas has one for you. And so, which means at the end of the day, the judge has to apply Arkansas law to essentially say this is where the assets of this person who's passed away this is how they should be distributed according to Arkansas law. So it's not a great position to be in. That's what probate is. So it can be avoided. So it's best at the very least to have a will so you can have your final wishes essentially codified or just clear for a judge to be able to see. but even a will itself won't avoid probate.
Yeah, and so when you are intestate, you don't have a will. So how does it go? So Arkansas has something called the Table of Descents, and generally speaking, what that means is who is next of kin? And again, we were talking about that a minute ago. If you don't have a will, it goes to next of kin. Well, if you have children, they're next. If you don't have children, it goes to your parents. If you have parents still living. If you don't have any parents, it goes to your siblings. And this is the order. And then if your siblings are gone, but they have children, it goes to nieces and nephews, and so forth and so forth. The problem with that is the state's deciding who your next of kin is. But what if you have a wayward child, you're estranged, and you don't want them to get anything? Well, you missed the opportunity to disinherit if that was your intentions. So the problem about intestate, again, is unintended consequences people may not have thought about. And another big problem with that is, what if you have children that are disabled? So again, if a disabled child inherits money outright, either because you didn't plan ahead with a will, with a trust, or whatever mechanism, then there's going to be some unintended consequences, and now maybe that child is going to lose their government benefits. And then there are other workarounds for that too. So again, everyone should have a will, at least, as if they don't have anything else. And so we encourage people not to die intestate. It usually leaves a bit of a chaos behind in their wake.
And some assets pass outside of probate, while others do not. What types of property are usually affected when someone dies without a will?
Essentially, as long as the asset is not left in the name of the person who has passed away, it won't go to probate, which means it passes outside of probate. So some examples of this would be, one of the ones we alluded to was a husband and wife owning property together. So they're both on the deed. But also related to that, what that is co-ownership of an asset. So, and ownership can be defined in different ways depending on the nature of the asset. But like another example would be a bank account with you, not necessarily your spouse, but you and a child, an adult child on an account. If you were to pass away, it would automatically go to the adult child without having to go to probate. So, and then there's some things to do so that have to do so with a statute or law, where it essentially says it will go to this person when they pass. So we try to implement all those things, or at least some of those things, to help you avoid probate, which is our big pitfall, I think, in this.
Yeah, and like Shane was saying, so beneficiary designations. If you have a POD on a bank account, TOD on an investment account, again, the beneficiary deed on real estate, those are beneficiary designations. But also trusts. So, we've talked about trusts. If you have trust and you have items owned by a trust, those all avoid probate. So there's multiple ways to avoid probate. And but a will does not avoid probate. Some people think that if you have a will, you can avoid probate, but a will is a ticket to probate. It's the instructions to the judge about what to do with your property. A will does not automatically transfer assets outside of probate. And so that's misunderstood. A lot of people think, I'm avoiding probate, I have a will. We have to inform people, I'm sorry, you didn't avoid anything. You're going to probate, because all you have is a will. You don't have beneficiary designations, trust, or whatever. So again, that's another common misconception about how to avoid it. And a will does not do that.
That's right.
Yeah.
And when there is no will, naming an executor, how is the person chosen who will handle the estate and manage the probate process?
I've had a situation like that recently where there was, it usually creates a fight because now you got people climbing over top of each other. It is kind of like first come, first serve. Whoever files the probate first gets to decide if they get to be the administrator of the estate. Now, in Arkansas, there is a period of time that a surviving spouse has 30 days option to file for probate. If they do that, then the state has a preference for the surviving spouse. After the 30-day preference period is over for a surviving spouse, then it kind of falls down to the children, and it's based on whoever files first. So typically, again, it creates a rush to probate by whoever's there. And typically that creates conflict from the beginning. And so, without a designated person, that's the reason why you want a will, because as testator of a will, we can say, well, I choose so-and-so. I choose my daughter. I choose my wife. Well, now they're the preference, regardless of how long it takes to file. So without the will, it creates this sort of rush, it creates the panic, particularly if there's conflict. And then, particularly if it's stepmom who survived. And, the children of the deceased usually get into a fuss with the stepmom. I see that a lot in my practice. So, yeah, it can be a mess.
I'm curious if you have an example, maybe a real life example or a situation where the absence of the will created unexpected complications for the family.
Well, I actually had one, I think it was this year, where that's exactly what the family was trying to do, was to essentially make sure mom's wishes were followed. And it was a large family, and they wanted to do so without officially trying to put a pen to paper. And over a few meetings it fell apart, and then mom went down, and it looked like her husband was being pulled from one side of the family. So, and not that a will would necessarily fix all that, but if mom passed and there was some issue, for example, in this case about her burial being handled a certain way, that would be something you could put in a will where at least the judge can understand what was going on. So,
yeah, and I had a friend who passed away. He was an attorney, by the way, and he was 70. He wasn't terribly old, but he died unexpectedly. Left his spouse, who is not the mother of his children, and he died about 3 years ago, and they're still in litigation. So if he had had a will, just think of all the issues that would have been avoided, because in this case, you got internal fighting amongst the heirs and their surviving spouse. That's usually when you have a problem. Now, if you don't have a step parent involved, it's usually a lot better. But, you still may have kids fighting. And, it's amazing. We see it a lot. If there's a little money on the table, you're usually going to have a lot of people wanting to be in control. What's going to happen? How's it going to be administered? And, the sibling rivalries really that have been dormant maybe for years start to show up again. So we encourage people not to do that to your family, and to plan ahead, of course. Yeah.
And then are there situations where the outcome under Arkansas intestacy law ends up being very different from what the person likely would have wanted?
Oh, certainly. So in a case where you have an estranged family member, child, for example, who, mistreated the person or for whatever reason, the relationship was destroyed, and everybody just knew, that person fled some years ago. It doesn't matter from the intestacy side that your relationship with that estranged child has no relevancy if you did not at least create a will and disinherit that person, which takes from your good children, and it makes them divide the whole estate with all the children, include the bad child, excuse me.
Yeah, and that happens a lot. I didn't think that would be the case, but the longer I've practiced, it seems like everybody's got a black sheep in the family that nobody, and then, I tell them, well, you need to have a will if you don't want them to have anything. And so we have to, counsel people on that quite a bit. And, but also just the other thing I brought up about having a disabled child. If you leave an inheritance to a disabled child, you're leaving them a problem with their benefits. And a lot of people don't understand that benefits, sometimes get denied or you lose them because you didn't think about, well, people don't like to think about dying, and so they don't think about their kids they're leaving behind that may need to have their inheritance in trust. And if you think about that ahead of time, you can put a testamentary trust in a will to protect that child. So by not having a will do that, then you're really handing a catastrophe to a child. And of course, none of us want to do that to our children. But again, people don't understand laws. They don't understand how benefits work. So always seek a professional. Always plan your estate. And we like to say, start at 65 if you hadn't done it yet.
Yeah.
For Arkansas families who have not yet created a will, like you said, what are some of the practical reasons to put one in place before a crisis occurs? I want you to motivate the listeners today to say, let's take care of this. Let's not wait till it's too late.
When you come to see me and you want to talk about a will, I'll tell you all about it, and then you'll probably pick a trust, right? Or some other reason. Okay, I'll be honest with you, but let me tell you the advantages of the will. You get to say who's in charge when you pass away, and you get to say how your assets are going to be distributed when you pass.
Yeah, I mean, a will is a way to honor your wishes, because your wishes may be a little different than what the state has.
Right.
And again, we've talked about that. So, yeah, we always try to motivate people. A will doesn't have to be that complicated. They're just people are afraid, and they don't want to talk about it. So you just have to have those conversations. Yeah.
Shane, I appreciate that you're always looking out for people. It's not just a will. There might be something better, but come see me, right?
That's right, Lisa.
Gentlemen, thank you so much for your insights on this episode. It's been enlightening, like usual. And to our audience, thank you for tuning in to the Jurist Law Podcast with Kimbro Stephens and Shane Cox. For more information or to connect with their team, visit juristlawgroup.com. Remember to like and subscribe to the show. Leave a review if you found this episode helpful, and we'll see you next time. Come on back.
Thank you.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.